In addition to the parent, who is, we certainly think, the most important member of the IEP team, the Individualized Education Program team, there are a number of other educators who are identified by law as being required to be there. In addition, the statute has a provision whereby, at the discretion of either the parents or the school district, another individual who has knowledge or special expertise can be invited to the IEP team. The statute says that at the discretion of the parent or the agency, other individuals who have knowledge or special expertise regarding the child, including related services personnel as appropriate, can be invited to the IEP team.
So, Jen, the way that I interpret that is, in addition to the people who are required to be there, any other person who is working with that child in his program can and might be at the IEP team meeting.
That's for the most part what this gets at. It's important to keep in mind a few pieces of information about that language. One is that it's at the discretion of either the parent or the agency, meaning the school district, the local educational agency. So the parent could elect to bring someone else to the meeting, and so could the school district. Where it gets tricky and where there become legal disputes is that the language says that the person who comes, the individuals who come, have to have some knowledge about the child or special expertise about the child. Now, where this becomes more problematic, the parent pretty much has a right to invite whomever they want to their child's IEP meeting. There are some cases where school districts have pushed back and tried to exclude someone from the meeting, but I argue that those are pretty tough cases for a school district to succeed on, because it's really up to the parent whether they want to bring someone with them. Where it gets more complicated is when a school district wants to bring someone, because keep in mind, this meeting is involving a child's private special education program, and it includes records that are private. And the school district can't just go around and invite the brother-in-law to the IEP meeting because they want them there. I mean, these are records, and the parent has to have given permission to a certain extent that they're disclosed and that this confidential information is shared. And so the problems come in where, as an example, a school district might want to bring in their attorney to an IEP meeting, even if the parent doesn't have an attorney, which does happen in some parts of this country more often than you think. And the argument that some parents and their advocates and their attorneys have made is, look, that person doesn't know my child, they don't have any knowledge of my child, and they don't have any special expertise about my child. They might have special expertise in special education law, but that doesn't give them special expertise. That argument hasn't really won the day for most parents. It seems to be somewhat permitted, though certainly not advised, to have a school district attorney at an IEP meeting, even if the parent doesn't have counsel. But it also gets into trickier questions like, if I wanted to bring in an advocate, would that be allowed? Yes, that's allowed. There's specific language in the statute about parents being advised and represented. But what about if the school district wanted to bring in a consultant who doesn't work with the child in the program in any way, but who they want to bring in? So this language really just sort of gives both sides an opportunity to bring in other people that they think could be useful to the team. But I give the caveat that it's not always as easy as it sounds.
So, Jen, the way that I interpret that, and the thing that I think that parents need to know, is that anybody who sits around that table on behalf of your child has to have some knowledge about your child, has to have some special expertise that they can bring to the table. And I think that's the important thing for parents to know.
I agree.